What is judicial review? Judicial review is the power of courts to pronounce upon the constitutionality of legislative acts which fall within their normal jurisdiction to enforce, and the power to refuse to enforce such as they find to be unconstitutional and hence void. Judicial review, said Justice Khanna, in the fundamental rights case, has thus become an integral part of our constitutional system, and a power has been vested in the High Courts and the Supreme Court to decide about the constitutional validity of the provisions of statutes. If the provisions of the statutes are found to be violative of any of the articles of the Constitution, which is the touchstone for the validity of all laws, the Supreme Court and the High Courts are empowered to strike down the said provisions. That power corrupts a man, and absolute power corrupts absolutely, which ultimately leads to tyranny, anarchy, and chaos, has been sufficiently established in course of evolution of human history, and all-round attempts have been made to erect institutional limitations on its exercise. When Montesquieu gave his doctrine of separation of powers, he was obviously moved by his desire to put a curb on absolute and uncontrollable power in any one organ of the government. A legislature, an executive, and a judicial power comprehend the whole of what is meant and understood by government. It is by balancing each of these two powers against the other to that the efforts in human nature towards tyranny can alone be checked and restrained, and any freedom preserved in the Constitution. Judicial review is thus the interposition of judicial restraint on the legislative as well as the executive organs of the government. The concept has the origin in the theory of limited government and in the theory of two laws, an ordinary and supreme, that is, the Constitution. From the very assumption that there is a supreme law which constitutes the foundation and source of other legislative authorities in the body politic, it proceeds that any act of the ordinary lawmaking bodies which contravenes the provisions of the supreme law must be void, and there must be some organ which is to possess the power or authority to pronounce such legislative acts void. The doctrine of judicial review was for the first time propounded by the Supreme Court of America. Originally, the United States Constitution did not contain an express provision for judicial review. The power of judicial review was, however, assumed by the Supreme Court of America in the historic case of Marbury v. Madison, 21 ed. 60. The facts of the case were as follows. The Federalists had lost the election of 1800, but before leaving the office they had succeeded in creating several new judicial posts. Among these were 42 justices of peace, to which the retiring Federalists President John Adams appointed 42 Federalists. The appointment of commissions was confirmed by the Senate, and they were signed and sealed, but Adams' Secretary of State, John Marshall, failed to deliver certain of them. When the new president, Thomas Jefferson, assumed office, he instructed his Secretary of State, James Madison, not to deliver 17 of these commissions, including one for William Marbury. Marbury filed a petition in the Supreme Court for the issue of a writ of mandamus to Secretary Madison ordering him to deliver the commissions. He relied on Section 31 of the Judiciary Act of 1789, which provided the Supreme Court shall have the power to issue writs of mandamus in cases warranted by the principles and usages of law to persons holding office under the authority of the United States. The court, speaking through Marshall, who had now become Chief Justice, held that Section 13 of the Judiciary Act was repugnant to Article 3, Section 2 of the Constitution, inasmuch as the Constitution itself limited the Supreme Court's original jurisdiction to cases affecting ambassadors, other public ministers and consuls, and those to which a state is party. Since Marbury fell in none of these categories, the court had no jurisdiction in his case. The observations of Chief Justice Marshall in that case are pertinent to note. The Constitution is either superior paramount law unchangeable by ordinary means, or it is on a level with ordinary legislative acts, and like other acts is alterable when the legislature shall please to alter it. Certainly, all those who framed written constitutions contemplate them as forming the fundamental and paramount law of the nation, and, consequently, the theory of every such government must be that an act of the legislature repugnant to the Constitution is void. And further, it is emphatically the province and duty of the judicial department to say what the law is. In the Indian Constitution there is an express provision for judicial review, and in this sense it is on a more solid footing than it is in America. In the State of Madras versus V0, AIR 1952, Chief Justice Patanjali Sastry observed, "Our Constitution contains express provisions for judicial review of legislation as to its conformity with the Constitution, unlike in America where the Supreme Court has assumed extensive powers of reviewing legislative acts under cover of the widely interpreted Due Process Clause in the 5th and 14th Amendments. If then, the courts in this country face up to such important and none too easy task, it is not out of any desire to tilt at legislative authority and a crusader's spirit, but in discharge of duty plainly laid upon them by the Constitution. This is especially true as regards the fundamental rights as to which the court has been assigned the role of sentinel on the qui-vive. But even in the absence of the provision for judicial review, the courts would have been able to invalidate a law which contravened any constitutional provision, for such power of judicial review follows from the very nature of constitutional law. In A.K. Gopalan versus State of Madras, AIR 1950, Chief Justice Kania pointed out that it was only by way of abundant caution that the framers of our Constitution inserted the specific provisions in Article 13. He observed, "In India, it is the Constitution that is supreme, and that a statute law to be valid must be in all conformity with the constitutional requirements, and it is for the judiciary to decide whether any enactment is constitutional or not." But while the basis of judicial review of legislative acts is far more secure under our Constitution, its potentialities are much more limited as compared to that in USA. This is due to the detailed provisions of the Indian Constitution and the easy method of its amendment, in contradistinction to the American Constitution's vague and general phraseology and the rigid method of its amendment. Thus, under the power of judicial review, the highest court of the nation can test all pre-Constitution and post-Constitution or future laws, and declare them unconstitutional in case they contravene any of the provisions of Part 3 of the Constitution. In Keshwananda Bharati's case, it has been held that judicial review is the basic features of the Indian Constitution, and, therefore, it cannot be damaged or amending the Constitution under Article 368 of the Constitution. Again, in L. Chandra Kumar versus Union of India, AIR 1997, the Supreme Court has held that the power of judicial review of legislative action as vested in the High Court under Article 226 and in the Supreme Court under Article 32 is part of the basic structure of the Constitution and can be ousted or excluded even by the constitutional amendment.